My name is Chidima Agu, and I'm a research and development staff at ESQ Training Limited. At ESQ Training Limited, our mission is to expand the frontiers of continuous professional learning. We offer courses and training across. Welcome, Mr. Sheung. We offer. Hello, welcome, Mr. Sheung. His network. Hello. Okay. At ESQ Training, we offer courses and training across various areas of practice. Hello, can you hear me? Mr. Sheung?
Yes, ma.
Okay. Welcome. Good afternoon. Good afternoon.
Okay.
Yes, so I'm just doing the introduction of the webinar. So at ESQ Training, our courses and training we cut across various areas of practice, which we have categorized into academics like the litigation and other dispute resolution academy, intellectual property academy, energy, oil and gas academy, tax academy, capital projects academy, capital markets academy, and many more. We have tagged this webinar series, launch our webinar series, as they are slated to hold at 1 p.m. during lunch break. They hold 3 times every week, Mondays, Wednesdays, and Fridays. However, on Fridays, we try to accommodate Muslim participants, and we hold Friday webinars by 11 a.m. And after every session, we always try to provide resources in easily accessible format on the go for everyone who's interested. Also, currently, registration is still ongoing for our training on PAR. It is a 12 weeks virtual distance learning course titled The Dynamic of PAR Contract Regulation, Contract Negotiation, Documentation, and Project Financing. So if you're interested and you need more information on that, please send a mail to o.solanke@esq-law.com. So the topic for today's webinar is on devolution of overseas assets in wills, and our seasoned facilitators will advise professionals on new industry trends and skills to flow into the new normal. And on today's topic, we'll be looking at understanding wills, gaining an in-depth understanding of dealings with estates abroad, identifying the practical steps in drafting wills for overseas assets, outlining the procedures under law covering foreign assets, and many more. And so we're privileged this afternoon to connect with our panel of experts. And if you have any question during the webinar, please type in the Q&A or raise your hand. So it is with great delight I introduce your speakers, Mr. Sheung Idowu, the head of private trust at Quantum Zenith, and our able chair and moderator of today's webinar, Mrs. Remy Ayla, who is a partner at Gunnar Cook Law Practice. She is an international private wealth lawyer with over 15 years experience. Her expertise cover all areas of private wealth advice, including wills, probate, and estate administrations, cross-border estate, tax, and trusts, including domestic and offshore trusts, trust drafting and administration, tax planning for UK and other jurisdictions, lasting power of attorney, mental capacity of protection application. Ms. Remi Ayla, thank you for joining us today, and thank you for moderating today's webinar. So I'll leave the conversation to you. Thank you very much.
Thank you very much. Thank you. So Sheung, do you wish to go first, or shall I? How would you prefer to play it? I'm quite happy for you to go first.
I'll defer to you. I'd love to go first.
Okay. All right. Right. So I'm going to share my screen. So hopefully we will all be able to have the same view. Yeah. So hopefully my screen is visible now. So I'm going to talk about certain issues regarding cross-border estates. And what I refer to as cross-border estates are estates where you have assets across more than one jurisdiction. So that's really what I'm talking about. So the first thing that I want to point out is the two main issues from my perspective that you need to be thinking about whenever you're making a will for somebody with cross-border estate. So firstly, you've got to think about succession laws. What succession laws apply in respect of the will that I'm making? So you can't sit in Nigeria and make a will for an asset in France and not consider what's going to happen when the end comes and that will has to be proved in France. So you've got to think about that. And then the other thing that I think is important is to think about what taxes apply. Sorry, I moved on a little bit too quick. But you have to think about what taxes apply because I know that in Nigeria, we don't pay too much attention to that, but outside of that, well, actually, I could be completely wrong, so somebody should correct me if I'm wrong, but outside of Nigeria, we're thinking of so many different types of taxes, and I'll come to that in a few moments. So in terms of succession laws, what are we thinking about? We're thinking, first of all, some countries have testamentary freedom, which means you can leave your estate to anybody you want. So you can do what the hell you want in your will. It's your will. So, you know, as some people put it, you know, you have the willpower. But there are other countries that have forced heirship rules. So with those forced heirship rules, what it means is that you're not free to dispose of your estate in the way that you want. So with some countries, they may say that a certain proportion of your estates, very frequently half, has to go to certain beneficiaries, to certain relatives. So it may be a spouse, children, and those sort of relatives. And in some countries, there are matrimonial law issues as well that restrict what you can do with matrimonial assets. So you've always got to be thinking, what's the situation in the country where this person I'm making a will for has assets? So if you come to UK law, which of course is my main area, you've got to think in terms of immovable and movable property. And in the UK, if you're looking at immovable property, the starting point is that it is governed by the law of the place where the asset is situated. And so if you're making a law in Nigeria, and that client of yours tells you that they have a house in the UK, you've got to think, well, UK law is going to apply to that disposition. Therefore, you have to make yourself familiar with what is going to apply when it comes to UK law. And for movable property, and everything that's not movable is, everything that's not immovable is movable. So that's everything other than real estate. That's governed by the law of the person's domicile. This is under UK law, so I'm not talking about worldwide. Every country has its own rules about how it deals with these things and what law applies. And there's even another layer of complication in the UK is a principle of conflict of laws called renvoi, where a court sitting in one jurisdiction can decide whether it's their own law that should apply or whether they should throw it back to the law of another country. So it can get really complicated. So for example, I've had a situation where there's a UK citizen with a UK deceased with assets in France, and there are in this particular case it was a minor who was inheriting, and the court in the UK decided that they were going to throw it back to France. And then France decided that, well, we're going to throw it back to you because this minor is habitually resident in the UK. So it can get really complicated. And that's why you have to be very careful and really look into what law should apply at the time of making the will. Because if you don't sort it out when you're making the will, then what you're leaving is a whole heap of a pile of mess to be dealt with in the probate, when you're getting the grant of probate. So you either deal with it now, or it's left to be dealt with later, when of course it's going to be much more expensive and possibly contested. The other thing I wanted to talk about in terms of succession laws is just to give you a flavor of what happens in other places, because I talked about UK, which is what happens to immovable property, what happens to movable property. In France, they apply a different set of rules, and they talk about habitual residence, they don't talk about domicile. And in Italy, for example, they talk about the law of the nationality of the person that died. So again, you can see that it's a different set of succession laws that might apply if you have a Nigerian national with assets in France. And then in Switzerland, they talk about citizenship. So as you can see, it can create a complicated level of different laws that could apply, and which could become very difficult to unravel. And when I get to the end, I'm going to tell you what I recommend that you should do in order to sort of overcome some of these hurdles. The good thing for the EU is that they have tried to harmonize their rules and make it a lot easier, so that you know what law to expect should apply. So there's an EU regulation, the EU succession regulations, which applies to deaths after 2015. We popularly refer to it as Brussels 4, Brussels 1V. And the good thing about it is that it gives you a default position, and the default position is that the law of the person's habitual residence will apply to their estate, but you can override that default provision by making an express election. So that means that when making a will, if it's an EU national, there is the option to put in a choice of law that will override the default position of habitual residence. So moving on now, the other area I wanted to look at is tax. I mean, tax. What do they say? That the two things that are unavoidable is death and tax. And the thing about tax is that different countries have different taxes that they apply. You have in the UK inheritance tax. In the US, you have estate tax. In certain countries, you have a death tax. You have gift taxes. You have wealth taxes. So when you're doing, making a will for a different jurisdiction, or you're making a will that cuts across more than one jurisdiction, you've got to be thinking, how does the tax in the country where this assets are situated, how are the taxes going to apply in respect of this testator? So it's really important to look at the taxes. I would just like to talk very quickly about inheritance tax. Actually, before I do, I'll point out again that apart from the different types of taxes, you also have the issue of the basis on which people are taxed. In some cases, it's residence. In some cases, it's citizenship. Sometimes it's domicile. And these can have different meanings depending on the jurisdiction. So I'm just going to talk very quickly about UK inheritance tax, because the connection with Nigeria and UK means that a lot of people in Nigeria who are making their wills have assets in the UK. And I actually have come across a lot of situations where we're dealing in the UK with Nigerian wills. So in terms of the UK, we have inheritance tax. That's the main thing that we worry about in the UK when it comes to testators, is what happens or what taxes apply on your death. Now, the important thing to be aware of is that as far as the UK is concerned, if you're domiciled anywhere in the UK, your inheritance tax applies to your worldwide assets. So wherever you have assets, they are going to fall within the UK inheritance tax net. And that's why when you're making the will, you've got to think about that. how does inheritance tax apply? Now, if it's a person that is non-UK domiciled, then the only part of their estate that will fall within the UK inheritance tax net are the assets in the UK. So the issue is, what does domicile mean? And I can tell you that we can have a week's lecture on the concept of UK domicile, because most people think it's where you live, but it's not. The concept of domicile begins with a domicile of origin. Everybody's born with a domicile of origin, which they take from their parents. And then from that domicile of origin, as you grow up, become an adult and you start making your choices, you can then have a domicile of choice. And that domicile of choice will be where you currently live, and where, provided that's the place that you intend to be your permanent home. So you might have homes in different countries, but there is one of them which is where you have as your permanent home. And the sort of things that would be looked at is, where is the place where you, for example, your children go to school? Not necessarily you can send your children to school abroad, but where's the place where you have your dogs, for example? Could be an indication of domicile, because if you have a holiday home in Barbados, you probably go there, spend some summers there, come back. But if you are somebody who loves dogs, you probably will not keep your dogs in Barbados. They'll be in Nigeria. And that is more likely to be the concept of your domicile of choice. There are other types of domicile as well. If you've been in the UK for 15 out of the last 20 years, you become deemed domicile. So you can make any choice that you want regarding domicile. The point is, your worldwide assets will come into the UK inheritance tax net. So that's something that we need to be careful about when making wills. And I'll draw it together on the next slide. The good thing about the UK is there's something called double taxation relief, and that applies where there's a treaty with another country that says, you can reclaim your taxes paid in one country in the other. But the good thing about the UK is that they do also apply this relief unilaterally. So even if there's no tax treaty, if you've paid some kind of death duty or the equivalent of inheritance tax somewhere else, you can reclaim it here in the UK, so that you're not paying the death duties twice. So moving on now, I'm almost at the end. I know that Shem is itching to jump in. Right, so on practical tips, the things I want to talk about is, when we are making wills here in the UK, we're thinking about inheritance tax. Tax planning is crucial and is at the basis of everything we do when it comes to wills. And there are different provisions that have different effects. So for example, when it comes to yes, I'll talk about tax planning first. Yeah, so when it comes to will trusts, for example, you have in the UK different types of trusts. Now, as far as common law jurisdictions are concerned, you probably understand the concept of trusts, and you probably understand the concept of interest in possession trust and discretionary trust. But we also have statutory trusts that have been created by statute in the UK, and they have been created to give different types of tax benefits. So for example, and I'm talking about will trusts now, you have in the UK an 18 to 25s trust that gives a certain inheritance tax benefit. You have bereaved minors trusts, so minors up to the age of 18. You have immediate post-death interest trust. You have disabled persons interest trusts. So these are all trusts that will give you certain inheritance tax advantages. So if you're not aware of them, you may create a trust that really impacts on your inheritance tax liability. So it's important. In the US, for example, we have, there's something called the Q dot, which is the qualifying domestic trust. And that kind of trust is something that will allow marital deductions, which is equivalent in the UK to spouse exemption. So let me just throw a conundrum for you. You have a couple married based in the UK. One is a US citizen, the other is a UK citizen. If I'm making a will for them, I won't have identical provisions, because with my UK spouse, I'm worried about making sure that the spouse exemption applies, which has the effect of deferring the payment of inheritance tax beyond the second death, giving the survivor the opportunity to do some further tax planning. And with the US spouse, I am worried about certain types of trust, the flexible life interest trust that I would do in the UK that would give me spouse exemption is a lot wider than the Q dot in the US. And that Q dot, I said Q dot earlier, it's Q dot. That Q dot in the US is much more restrictive in the way, in terms of the provisions. So for my US spouse, I'll be putting in a Q dot. For my UK spouse, I'll be putting in, it's called an immediate post-death interest. That's what I'll be putting into their will. So you can see that there are different types of provisions that you have to think about in terms of the spouses, depending on their citizenship, their residence, their habitual residence, which are all concepts that we have to grapple with. The difference between common law and civil law jurisdictions are quite important, because common law civil law jurisdictions commonly do not recognize trusts. So if you're thinking of putting trust in the will, then you might not do very well when you're making provisions for a French property or a German property in the will. The other thing to think about are issues that can arise on probate. Foreign wills are valid in England and Wales and Scotland, provided it's executed in accordance with the laws of the country in which either they were executed, or that the testator was domiciled or habitually resident or was a national of at the time of execution or death. So the good thing is your will in Nigeria will work for the UK. However, it may not work for very well for inheritance tax. So that's the thing to be aware of. So normally what we would do in the UK is to reseal the grant, but in the UK, not all grants are going to be possible to be resealed. For example, a US grant can't be resealed in the UK. It's mainly the Commonwealth countries, but not all of them. So that's something to be thinking about, is, start with the end in sight. So the end is going to be probate. When it comes to probate, how is my will going to be received in the country in which there are assets? Then you've got to think about will disputes. Increasingly, there's a journalist that wrote an article and said that Britain is becoming a nation of inheritance vultures. But I don't think it's just Britain. I think this is happening all over the world. People are seeing inheritance as an easy way to increase their wealth. And so you have to be really careful. In the UK, the law is that, I think most of you will understand the issue of the concept of privity of contract. So you would normally think, well, contractually, my duty of care and the duties I owe are to my client. Who's your client? The deceased. So you're thinking, well, that means that the client can't actually sue me after they're dead. But the UK courts have ruled that you owe a duty of care to the not just to the beneficiaries of the will, but to the intended or disappointed beneficiaries. And so you have to think about professional negligence and potential liability. And so my final tip is different wills for different jurisdictions, because I don't make wills for the US. I will work with a US lawyer to make the will. But what I will do is coordinate it. I'm currently dealing with an estate where there's a US will, but the US will has unintentionally revoked the UK will, when in fact what was intended was that there should be a UK will and a US will. So it's important that if you are dealing with the estate of, say, a Nigerian in Nigeria, who has a property in the UK, has property in France, has property in the US. Work with UK lawyers, US lawyers, French lawyers, coordinate it all to make sure that one will does not revoke the other. And of course, you've got the issue of interpretation. So you get a French will, make sure it's in French, but that it is officially translated so you know what it says. But you have the French original that makes it easier for probate in that country. And so finally, if you are interested in knowing more about UK wills, I do have a book, and if they make the slides available for you, you can get it from Amazon. Otherwise, you just type in bit.ly/making a will, the book. And finally, if you are being given the slides, I've got my contact details. Always happy to connect with lawyers from all over the world, particularly lawyers dealing with wills and family inheritance. Thank you. I hope I haven't eaten too much into your time, Shil.
Not at all, not at all. I've been enjoying your talk.
Okay, so
Yeah.
right, over to you.
Yes. Okay, so let me try to share my screen. Good afternoon, everyone. Hold on, please. Okay, I don't know if it's on now.
Yes, it's on.
Okay, great, fantastic. Okay, so good afternoon, everyone. Let me just jump into it, and thank you very much.
Could you put it on slide, and then I'm going to mute myself.
Can I do what?
Slide view at the bottom.
Okay. Hold on.
Yeah, the next one. No, to the left.
Oh, okay. This. All right. Okay, great. Okay. So good afternoon, everyone. Once again, thank you very much, Rui, for the introduction. Very well, very detailed, and I have very little to add. But I mean, I think it's important also, if you're tackling this kind of topic, to, I mean, go back to the basics. I work with a lot of lawyers, and I have realized that a lot of things that we get taught in school, maybe we forget or something, you know. So you know, some little refresher course is important. So I want to go back to what exactly is a will, especially as it relates to this particular topic. Yeah, so we all know what a will is. It's a written instrument containing directions on how the assets of the person making the will should be divided or distributed upon his or her death. And essentially, it lets you choose an individual or trustee to serve as the executor of your estates, and the executor will manage and sorry, hold on, please. Yeah, okay. Okay, so the executor will manage and settle your estate according to your law. So that's that for introduction to wills. And what should a will contain? It should contain the identity of the person whose will it is. I think all these points are very important. The beneficiaries of the estate and the distribution of the assets. And it could contain a cost for setting up a trust. And that goes back to the point that I think you were trying to make, Bruni. And we may touch on the issue of trust later on as to whether I know this topic is about wills, but I mean at the end of the day, we might want to guide people as to know, okay, so should I do a will? Should I take out a will, or should I just set up a trust? But we won't dwell too much on that. And of course, guardian nominations in a will, very important. And then, of course, your executor. Now, I think it's also important to see what the Nigerian law says with regards to devolution of assets under Nigerian law. So, yes, probate is required for administration of estates. And I've already mentioned this. A will gives the executors powers over the assets of the deceased, but probate affirms that authority. So that's going back to the mischief rule. Why do we even have probate in the first place? Then, of course, the procedure, interested persons have to apply to the probate registrar for a grant of probate. And I'll explain why I'm trying to draw these distinctions, because we're talking about making wills. I believe that we're talking about making wills in Nigeria vis-a-vis and how if you have foreign assets in those wills, everything could be affected. So those processes are important. And then the probate registry has, in Nigeria, the probate registry has the exclusive, probate registry of the High Court has the exclusive jurisdiction to grant probate. For real estate assets, so this is after, in the process of trying to grant probate, they will appoint someone from the evaluation unit of the registration, from the probate registry, to conduct inspections and evaluate the properties in order to assess estate duty payable. That goes back to the issue you also raised regarding tax. We'll get back to that later. And okay, so next point, which now flows into the real topic. Probate is usually granted for properties within the jurisdiction in Nigeria, jurisdiction of the state where it was granted. So it essentially means that if any property falls outside the jurisdiction, the executors will have to apply for the resealing of the probate in the High Court of the states where the property is situated. And Section 2 of the Probate Resealing Act provides for that. Now, to the topic, dealing with estates abroad. I only have broad tips regarding this topic because, like you really rightly mentioned earlier, Remy, it is the wisest thing to ever do is to take out or to make wills for each property that you have in different jurisdictions because laws differ in different jurisdictions. Okay, so back to the topic. Section 1 of the Probate Resealing Act states that probate granted in any Commonwealth country, you mentioned that earlier also, may
Sorry,
also...
Mr. Sheung. Please,
Okay, yeah.
we can hardly hear you.
Oh.
Yes.
Oh, okay. Oh, wow, and I've been going on.
Sorry.
Okay, so where did you lose me?
Because some panelists are saying they can't hear most of the things. Sorry, some attendees are saying they can't hear.
Oh, okay. Okay, so let me just go back to this slide because I think that's it. Okay, so can you hear me now? Chidema?
Yes, I can. Yes.
Okay.
Yes.
I want to believe everybody else can hear me too. Please let me know. Please feel free to stop me at any time if anybody can hear me.
Well, I could actually hear you quite clearly.
Okay.
It may be that some people are having issues with their
internet issues. Okay. I'll just keep my mic close to my mouth then. Yes, no problem. Okay, so I started by saying that probably by trying to explain the process of granting probate and essentially devolving assets under Nigerian law. So probate is required for administrations of estates generally in Nigeria, and a will gives the executors powers over the assets of the deceased. Essentially, that's the first step. But probate, what probate does is to affirm, validate that authority given to executors or administrators, executors generally, and beneficiaries under a will. I also mentioned that interested persons, of course, the process have to apply to the probate registrar for a grant of probate, and interested persons will be executors and beneficiaries. Then, yes, we know that the probate registry of the High Court of each state or of the state in which the asset is located has exclusive jurisdiction to grant probate. Now, I mentioned that for real estate assets, so say you have a home or anything that you want to pass on to your beneficiaries, what happens is that when they want to take out that probate, the evaluation unit of the registry will have to conduct inspections and evaluate the properties in order to assess estate duty payable. So that goes to the issue of tax that we're trying to make the other time. I mean, I know that essentially what this session is all about is to open people's minds as to what to consider and what to ensure that they take care of when writing a will.
Sorry, Sharon, do you mind not holding your mic too close to your mouth, because there's some wind issues? Yeah, thank you.
Oh, okay.
Yeah, thank you.
I don't know if is this.
No, I mean you can hold it, but just not too close. Is what I'm saying.
Okay.
Thank you.
Okay, thank you. Okay, so for real estate, okay, I mentioned this already. So probate is usually granted for properties within any jurisdiction where the states. Probate is granted for properties within the jurisdiction of the states where it was granted. So it means that if any asset falls outside the jurisdiction, the executors will have to apply for resealing of the probate in the High Court of the state where that property is situated. And Section 2 of the Probate Resealing Act provides for this. Then going to the topic of dealing with estates abroad, with properties abroad. So essentially, if you have written a will and you've included foreign assets, overseas assets in that will, how will that will be construed? How will those assets be distributed? How will probate be granted in that scenario? Section 1 of the Probate Resealing Act states that probate granted in any Commonwealth country may also be resealed in Nigeria. That's the first step. And of course, that will bring to our minds that the issue of, okay, so what happens if it's not a Commonwealth country? We'll get to that. And the effect of that resealing is to render that resealed grant effective in the state as if it was granted by the High Court of that state. So it's just another process of, revalidating an already valid instrument. Okay, so, well, I've listed the condition. I don't think we need to go into that for dealing with estates abroad, because it's just the conditions for resealing. There's an estate duty to be paid. And of course, you fill out an application form, take out an oath, and then give an inventory, provide an inventory of landed properties of the testator, and take out a bond. Now, general advice, and this is what happens when we advise clients over here in our company. If you own assets outside the country or are a beneficiary of an overseas estate, then you probably need to conduct probate in more than one country. That's the truth. It looks tedious, but this is, we know how wills are, and we know that essentially you just want to avoid, um, on the part of the testator, you want to avoid creating problems for your beneficiaries. And of course, because I know personally that there are some, I've had to deal with something like that, some issues like that, where beneficiaries can't even access, gain access to um, properties, assets left to them in wills, simply because, for example, they can't, there was no provision for certain things, or some property was left out of it. So it's something that one has to be very careful about. So if you own assets outside the country, or a beneficiary of an overseas estate, you will very likely have to conduct probate in more than one country. And also bear in mind that we also mentioned the fact that resealing, as described earlier, applies only to Commonwealth countries. I mean, that's in relation to Nigeria anyway. So to avoid complications, it's just important to ensure that wills are drafted in a manner, this is to all lawyers, in a manner that facilitates a seamless transfer of assets. So do, as advised earlier by Remy, ensure that as a lawyer, you work with, you create partnerships with lawyers in other countries where those assets may be, and just work with them and coordinate, just like as advised. And that's exactly what the procedure has been. That's our normal procedure here at our company, and it gives you a lot of it gives you rest of mind as a lawyer. So that's that. So in short, a testator should ensure that the will clearly addresses all the jurisdictions where there are assets, in order to totally prevent ambiguities or disputes. Very important. And as mentioned earlier by Remy, and I also mentioned it earlier, every country has its own unique probate laws that must be adhered to for the will to be valid. In fact, I know for a fact that, I think Remy might be able to help me out here. I know that there are different probate laws for different states in the United States, for example. Please correct me if I'm wrong.
No, that's correct. That's
Yes.
correct. And even
Yes.
the issue of testamentary freedom, there is one state, I forget the name of which state it is. There's one state in the US which shockingly has forced heirship rules. So,
Yeah.
so you're right, absolutely.
Yes. So these are all things that one needs to really consider if one is drafting. And I'm approaching it from two angles. You as a lawyer helping your client draft a will, and even as I mean, yes, we're lawyers, but I mean, every lawyer also will want to draft his own will. So definitely, there's advice for you as a lawyer who is advising a client, and as a testator yourself. So this is very important. More advice is that, okay, so examples again, in certain jurisdictions, just like Remy said, the law distinguishes between movable and immovable assets um, when establishing whether a will is legally valid. So when it comes to movable assets, such as shares and bank accounts, the will must comply with the formalities of the home country at the time of the testator's death. While to devolve immovable assets, such as land, the law of the country where the asset is located takes precedence. So all these things, I mean, there are things to consider, and one has to be very, very careful as a lawyer when drafting. And then, well, like I mentioned also, a reasonable thing to do will be just draft separate wills as a testator anyway for each asset in different jurisdiction, in order to avoid quote wahala. Finally, stressed earlier, pay attention to the particular laws of the countries that of the countries in which those assets are located. It's very difficult to in a session like this to be able to address different what applies in different jurisdictions because we might be here till next week, you know. So that's that from my end for now. We'll wait for questions. Thank you.
Thank you very much, Sharon. That's been really helpful. I do wish that you had gone before me because I made certain assumptions, but thank you very much for coming and clearing up all those things because I think it was very important to go back to basics and just not make assumptions about everybody's level of understanding. So that's really good. Thank you very much.
Thank you.
So do we have any questions? I think you're supposed to either raise your hand or maybe type a question in the chat box. ESQ people, what do you?
There are no questions and the Q&A or there are no questions for now. There are
Okay.
no questions. Yes, yes. But thank you so much for this insightful session today. Thank you, Mr. Sheung. Thank you, Ms. Remi Ayla. It has really been an amazing topic and we've learned a lot. At least now I can go and buy a house or a land in the US.
And make your will at the same time.
Exactly. Thank you for this well-researched content, and a very big thank you to our sponsors, GLIS and Co, and Advocate Law Practice for making this webinar possible today. Thank you also to all the attendees, even though there are no questions today, but thank you so much. Please note that our next webinar series will be titled Collecting Information and the Use of Private Investigators, and it will be coming up on Friday, on 26th of February by 11 a.m. It promises to be very informative and we look forward to engaging you all there. Thank you so much, Ms. Remi Ayla, once again. Thank you, Mr. Sheung Idowu, and thank you all for attending today's webinar. Enjoy the rest of your day.
Sorry, before we go, whilst we still got people on the line, I wanted to go back to something that Sharon raised. Is it okay to do that?
No problem, yes.
Definitely.
Okay, so Sharon, you mentioned about setting up a trust.
Yes.
And I would agree with you. Well, I don't know if you were advocating that, but I definitely do advocate people considering setting up lifetime trusts as opposed to waiting and doing it in the will.
Yes.
With the UK, there are, and certain other jurisdictions, there are issues, tax issues relating to trusts. So if you say you want to set up a trust of your lifetime trust of a UK assets, definitely I would not recommend doing it anywhere outside the UK. You need to do it with a lawyer here in the UK so that tax issues can be addressed. But leaving tax issues aside, some of the things that for me make it quite helpful to deal with assets in a lifetime trust as opposed to dealing with it in the will are things like you're doing it at a time when you most likely have full mental capacity. It's much more difficult for anybody to allege that you were coerced. It's much easier for you to take proper advice, and it settles the succession to certain assets. So yes. I do recommend it, provided that tax-wise that the tax favorable. But even sometimes when it's not favorable, there's a saying, don't let the tax tail wag the dog. So it's not always about tax. Sometimes it's about settling the disposition of certain assets in your estate. And you might want to do it in your lifetime to ensure a proper and orderly succession. And of course, once you've made the will, the trust in your lifetime, then it means that the will does not deal with that asset. And it also means that when it comes to your will, anybody wanting to challenge your will, that asset that you've already put into trust is automatically excluded because it's not part of your estate anymore. So
Exactly.
I wanted to agree with you on that.
Yeah, thank you for that. I'm sure we'll have more sessions that will deal particularly with this particular topic,
Yeah.
wills and trusts, and which one to take at particular, what assets to assign to which one.
Yes.
So thank you very much for that.
I would definitely recommend to ESQ to have a session on trusts.
Yes.
Because I've seen wills here with trusts in them, and
Exactly.
we're looking at it and wondering, is this a trust or is it not? It's
Yes.
intended to be a trust, but the drafting leaves it very short of actually being a proper declaration of trust.
Yes.
And you know, when you're scratching your head like that, it means money because somebody has to pay for somebody to figure it out.
Exactly.
And so usually it's the estate that's losing out because they're paying for it.
Yes. Thank you for that.
Okay. All right. Well, thank you very much for the opportunity, ESQ. I think it's been really insightful. And thank you also, Sheila. I've learned, you know, from you as well. Thank you.
Thank you
so
very
much.
much. So I'll make my own slides available.
Yes, please. Okay, thank you so much once again.
Thank you.
Have a nice day.
Have a nice day. Bye.
Have a nice day. Bye.
Okay, bye.